This professional regulatory event has become an annual enterprise. It's the fourth time that our group has presented this workshop. Its genesis was really in the work that I need to do on a semi-annual basis, updating my book, The Regulation of Professions in Canada. And as part of that, I have to review every reported legal case in Canada on professional regulation to see what's new, what should be added to my book. We review probably in a typical year between 150 and 200. And from that work, we began to think, wouldn't it be a good idea to present to regulators on an annual basis, a year in review, go through all these cases, choose the ones that we think are most important, and present it in a very time efficient way for regulators. And that led to this workshop being developed. When we choose the cases to present, we look at, is the legal principle important? Does it show an important trend? And then for each case, we look at the context. We set the context, we talk about the case, and then we address trends and implications for regulators.
So the context here is that most statutes include provisions to prevent those who aren't members of the profession from using protected titles or holding themselves out as members of the profession. These provisions exist to protect the public. For one, protected titles make it easy for members of the public to know when they're dealing with a regulated professional. And as part of the protected title scheme, most statutes empower regulators to seek injunctions from the court to prevent individuals from using protected titles when they're not allowed to.
This case, the facts involve a collision of issues. Social media, number one. Number two, private conduct. And number three, freedom of expression under the charter. And we know social media is so widespread in today's world, so it's used by many professionals to communicate with friends and others in both their professional but also their private lives. But social media by its nature raises questions about what is the appropriate boundary as to when a regulator can engage and not engage when an individual is on social media, speaking as a private person, sometimes not so private, but also identifying themselves as a member of a profession.
So for sexual abuse claims, that's a topic that has been front and center for regulators for a number of years now. We're starting to see that numerous provinces have enacted legislation which makes certain sanctions mandatory when there's been a finding of sexual abuse or sexual misconduct. And in some cases, the legislation has been a bit vague or unclear about the transition. So there have been questions about whether the mandatory sanction applies if the legislation was not yet in force when the conduct actually occurred, or perhaps when the complaint was received by the college. But as more cases are decided and as more time passes from when this legislation was first enacted, we're starting to get a bit more certainty here.